to Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com. Today our guest is Representative Jim Nielson, who began serving in the Utah House of Representatives in 2011 and also was an appointee in the Reagan Administration from 1983 through 1988. Today, Representative Nielson is going to speak with us about his proposed bill in Utah that would require couples to take mandatory divorce orientation classes sooner than they do now. Representative Nielson, thank you very much for joining me. I appreciate it.
Thank you for having me, Matt.
So let's talk a little bit about this time frame for the divorce orientation class. What would your proposal, this proposed bill, change in that regard?
The current law says when you take this course, you have to complete it, or when you file for divorce, both parties have to complete it within a certain number of days. The problem is, and it's either 30 or 60, I can't remember, but the problem with that is that there's nothing in the court system or in the statute that functions as a trigger and makes sure that that happens. The only thing after filing, the only thing in the courts that makes sure that it's completed is finalizing the divorce. And so what typically happens, because there's no enforcement and no mechanism to see that it happens, is most couples, probably 90% of the people that take the course, take it within the last week or two before the divorce is complete.
So let's talk about the pros of this bill. What do you think will be most beneficial about this proposed change?
Well, when you think about the reason that lawmakers many, many years ago created this course, it seems that the goal was to make sure that people were aware of the impact of the decision that they were about to make, that they would be more aware of the kinds of consequences that might happen. They'd be aware of possible positive and also possible negative consequences. They also hoped that people would be more familiar at the beginning of the process with what the process would be like, how it would affect people, who would be impacted, what decisions regarding children might happen, and so they'd know what they were facing and what the steps they would be going through, and potentially an idea about what some of the impacts would be. It also, the course is set up to help people understand what potential alternatives there are to divorce, things that could happen through a non-judicial process, any kind of negotiated resolution or things like that. They wanted people to be able to know what their options were. If you get all this information at the end, right before the divorce is finalized, it's of little utility.
Well, now let's move on to the cons. Obviously, it's a bill, so there are going to be some opponents to it. What issues do opponents to this bill have with the proposal that you're aware of, and how do you feel these can be resolved to make sure this bill moves forward?
Well, there's a couple of things. There's a group of people that would like to take aim at the course itself and say, we shouldn't do anything, we should just get rid of the course. It's the idea that the state has no business telling people what to do, and the state should be just totally uninvolved. I've always felt that the state does have an interest when children are involved, and that things that help inform people make sense. Now, there's another group that opposes it because of a concern about, or at least they brought questions to the forefront, having to do with, their concerns have to do with access to the courts. We're required to make sure that everybody has free and open access to the courts, regardless of their financial means or anything. What we've done in an attempt to address that is, one, the bill makes it possible for this course to be administered online, and two, the fees that have been charged for the course we are eliminating, and instead putting those fees into the cost of the divorce filing itself and the divorce settlement. So the course is at no cost. Anybody can take it anytime. There's a waiver for people that may feel like they're in harm's way if their spouse were to find out about it. And as I say, it makes it, and we make it possible that, again, maybe I already said this, it's no cost for the course. So we think we've addressed the issue of, and we make it available by video, that's what else I said. But we think that we've addressed the concerns about access to the courts. However, I'm in contact with the court administrator's office that spoke about this, and I'm looking forward to a conversation to make sure we resolve any further items related to this issue of access to the courts.
And finally, let's talk about the impact on children. Our primary audience, obviously, single divorced fathers raising children that are going through a divorce or have already been through a divorce. Would this proposed change affect children of a divorce in any way? And if so, what would that impact be?
Well, I would say that based on what little I know, and you know this better than I do, that the friends that I have that have gone through a divorce, most of the people I know that have been through that, I know personally, are men. And my sense, at least from the men that I interact with, is that they've usually been surprised by the divorce request, by the filing. And so they're in the position of the respondent. And the ones I've known generally also have been greatly distressed by it and wish that there had been an opportunity to reconcile or to find a way to reconcile. I think it happens far more commonly than people realize. So if I'm correct that more of the filers are women than men, and that's based on just anecdotal information, then I think what this course does, which basically mandates that before you file, the filer, who's the one taking affirmative action, has to take this course. That individual, often a woman, will be aware of alternatives, will be aware of the impact, and be aware of the consequences, and know what the process will do to his or her family. I think it at least provides a little bit better information to that individual. And there are going to be a few cases, this is based on research from a family life professor I've spoken with, there are going to be a few cases where that information will make a difference and may actually help a person have second thoughts about whether to proceed through the courts. What it does for children is just related to that. I think the person filing for divorce will be more aware of the impact of that decision on children. There's recent research on the issue of what, again, the same professor refers to as called, I think many people use the same term, which is unnecessary divorces. And the research suggests that there is a not insignificant number of people that start down the divorce path where both couples both parties to the couple, both the husband and wife, contacted individually, wish that there had been an opportunity to consider reconciliation. And in some of those cases, had they realized that there was such an opportunity, the divorce might not have happened. So that's a significant impact on children. If somehow we reduce the number of divorces, I think it's a significant impact on many men as well, particularly men who are caught off guard by a divorce filing. There will be, I believe, a few cases where that simply won't happen because of better information.
So, Jim, thank you very much for joining me today. I really appreciate it, and best of luck with the bill.
Thank you for having me, Matt.
That was Representative Jim Nielson, who has been serving in the Utah House of Representatives since 2011. I'm Matt Allen, editor of DadsDivorce.com, and that'll do it for this edition of Dad's Divorce Live.